you let people know that so that they don't suddenly bring kids out of school and have them sitting in the hallway only to find out you're not going to talk to them anyway?
I look at it two ways. Children are invested in this process too, and sometimes they feel disenfranchised if they haven't spoken to somebody, and they know there's a guy or a woman in a black robe that's going to make a decision about them. Now, sometimes I think I should listen, talk to them merely to know that they know they've been heard. And I always tell them when I talk to them, I appreciate what you're saying, but my job is to make the decision. That's not your job. It's not your responsibility. But you've been heard. But I do, when parents say, I want to bring my child in as a witness, I admire the hair. I bare my teeth and start rattling. And because it's just not a good thing. And I've had it with kids on the stand, 13, 14, and the mom and dad are here, and the lawyer's asking questions, and it's just, I can see 10 years, it's not going to be repaired for 10 or 15 years. I discourage, I tell lawyers, I think if you're going to put your child on the stand in the middle of this, merely talk about what a schmuck dad is or what a schmuck mom is, and that's what it is, that's what it boils down to. You're just creating problems. If that's what you're going to do, I'm going to consider that in my evaluation of your ability to promote relationship with the other parent and how you're looking at your child, because I think it's destructive. It's destructive. It's usually just, especially when you get 13, 14, 15-year-olds, and they've been separate households, and those kids are problematic anyway because they're in middle school, they don't have a brain, it's gone. And I say that from experience because I was a middle schooler, I know that. But, and you know what happens is, whoever's got custody is saying, okay, you can't go stay out till midnight, you can't do this, you can't do that. And then the other side is going, well, the other parents go, come on with me, we'll go party, stuff like that. Not literally, but and so I want to go live with dad now. And that they tell me, I want to live with dad because mom is mean. That's why your mom is mean. And I think giving a child that power is so destructive. You don't give it to them. But that's what you're doing.
So do you tend to have lawyers in your court understand that they're taking a big risk when their client wants to have the child come in?
Well, in the 3 minutes I've been talking, you get a sense how I feel about this?
Yeah.
And only because I've seen it. I've seen it. And if I had gone on the bench a couple of years, I probably wouldn't. But I've seen I've had the benefit of seeing, 18 years hence, and kids, 10 years hence, and mom and dad just create this division, and you're asking a child to say, my dad's a bad person, my mom's a bad person, and that's not forgotten. It's not forgotten easily. And so I discourage it unless there's something significant I'm going to get out of it. And I don't know what that would be. I talk to the kids. Having it on the record, I know you're required to do that, but and we were just talking about earlier, it's on the record, and talking to me in chambers alone, on the record, usually my law clerk's in there with me, but they get a record of it, and then the person who doesn't win gets a copy of the transcript, and I'm sure that he's experienced, they go to the kid and say, this is what you said about me? This is what you said about me. I know that's happened.
That's the nice thing about not having a record.
No.
My view is that, of course, I don't think children belong in courtroom generally, but, there is a reality here, too, and that is there are certain situations where I think the parents can really agree in advance what the child is going to say they know. But there are other situations where, in hotly contested cases, we have parents who are, through their counsel, are making legitimate objections to hearsay. And so sometimes parents, to prove facts, have to use the child as a witness. I mean, I understand that. Now, that's not pleasant, but it's just a reality that there are certain facts that are in the, hidden in the home, so to speak. And only one person, other than the parents themselves, is going to break the tie. That's sad. But it's a reality. They may be fact witnesses about certain aspects. Again, it all depends upon the particular circumstances. But in terms of preferences and things of that sort, a lot of times the parents know that, and they can stipulate to that and agree that's what's going to be said.
How often have you had a child testify, to provide something that was dispositive in your case?
I've had that happen, where suggestions are that a parent is telling a child to go be a witness and get evidence, gain evidence, things that, and denies it on the stand, and then child wants to confirm it. And how do you prove that? And that's an unfortunate circumstance to put a child in that, but there are circumstances like that, and it's regrettable. But how you handle the in-camera interview is an important aspect too, because there are times when I think the parents need to give questions to the judge. I think this is a role that all the attorneys need to think about: is walking in, there are times when you're surprised when you see the children there. You didn't expect it, and I guess we all should always expect everything. Hope for the best and expect the worst. But the reality is, you should always probably prep and then think about the questions that you would like the judge to ask. And if you're not going to be present, think about the concept of not having a record to make it a little less formal for the child, because of the problem Judge Rockwell was talking about that I've experienced in my private practice, where a very needy parent, after losing, sat down with the child with the transcript and went over it with them. And putting restrictions on having a parent ordering the transcript without permission of the court. I mean, there are all kinds of things you can think about. The setting, depending on the age. I have to think about, do I wear a robe or do I take my suit jacket off? Will it be better for the child depending on the age? Just as he said, I have a law clerk present. I just have a female bailiff, but she has a uniform, but I want them present for my own protection, because I don't want someone to suggest I did something inappropriate. And so there are all kinds of things to think about the setting. I've had parents before with older children, and I suggested this. I said, you all could agree to take less pressure, to take the pressure off the children. This is a 15-year-old, 16, so they're old enough to be a witness. They don't have to have an in-camera interview. And the lawyers want to use the direct and cross-examination. I said, listen, this is a civil case. If mom and dad would like to get up right now and go to use the restroom and step outside during this examination, you're free to do so. Give them an opportunity to take the pressure off the child. So there are many, many things that you can do, hopefully creatively, both as a judge, but more importantly as counsel, to think about ways to lessen the impact on the child or children.
I seldom have ever allowed children to testify in court, especially when the parents are present, because all it's going to do is create additional conflict within the family, and there's already enough conflict as it is. I do, however, almost always take them back into my chambers to talk to them. Most of the children want me to talk to them. They are obviously the biggest stakeholder in the process. And I had two young girls in a case, I guess it was last week. It hasn't been long ago at all. One of them was 6 and one of them was 8. And when the guardian ad litem stepped into the courtroom and I was sitting there and said that the judge would like to speak to both of you all, they went, yes, because they were just dying to talk to me and tell me what they wanted to be heard. What I do to sort of relax them is I go back to my chambers by myself first, take my robe off, hang it up, put on a wig and a pair of Waldo glasses. Where's Waldo? You know who that is. Something of that nature, just to lighten them up. One poor young boy walked in, didn't know whether to laugh or cry because he wasn't sure if it was my real hair or my real glasses. But once I took the wig off and the glasses off, he immediately bonded with me and thought I was the coolest guy he'd ever met. Told the guardian how much he liked talking to me, but he loosened up. They come in there, they want to talk to you, but once they get in there, they get nervous. And they're afraid to say anything bad about either parent because they're afraid that they don't understand that level of confidence between you and them, and they're afraid that whatever they say may get back to the parents, and they don't want that to happen. So you have to go to great pains to let them know that this is an entirely confidential conversation that I have with them, and that I'm going to make the ultimate decision. But my decision may or may not be based upon what they've told me, but in any event, the parents won't be told, that the input of the child, what the input was and what bearing it had, if any, on the outcome of the case. But as far as, I would say, in the hundreds of custody cases that I've heard in the last 11 years, I can count on one hand the number of times I've allowed one of the children to testify, and in those cases the child's normally 16 or 17 years old, and there's a very, very good reason why that child needs to get on the stand, because there's something very terrible about one of the parents that needs to be told, and the child wants to tell it. But for the younger children, never. I just think I just don't think it's good practice to do that.
Do you ask the child the ultimate issue when they come in? Who do you want to live with?
I don't normally phrase it that way. I try to work around it and ask them about what is it about this, this parent you like. What is it about this parent you like? One of the things I do, and sometimes this will elicit a good response. If I told you right this minute that I'm going to go out there and say that you have to live with your father, what's your reaction? And I see how they react, and I say, now, if I tell them you're going to go out there and say you have to live with your mother, what's your reaction to that? And sometimes they will open up just based upon what I tell them I might do, and that reaction says volumes about, or speaks volumes about what's really in their heart and what they really want to do.
I'll try to avoid asking that question.
Sure.
ask them usually, as my law clerk say, what music you listen to, and you know what TV shows you watch. You can't hear me? I'm sorry. I don't ask them sorry. I don't ask the ultimate question generally until the end of the conversation, and that only usually comes in the form of, well, is there anything you want to tell me? And invariably they say, I want to live with my mom at the end of the conversation, because that's what they came expecting to say. But in the course of my chatting with them, I ask them about, what do you do with dad? What do you do with mom? What do you like? Who do you hang out with? Where do you have friends? That kind of stuff. What kind of music do you like? What TV shows you watch? What sports you do? And what do mom and dad do with that stuff? But invariably at the end, I say, anything else you want to tell me? They say, I want to live with mom, I want to live with dad. Because that's what they've been prepared to say, knowing the court was coming. So, I don't want to give them that. I don't want to give them that power, because then I think they need to know they've been heard, but they don't need to think they've made the decision. So
I've tried to do basically the same thing. In other words, try to get them to tell me, but without asking them. In other words, get into it a different way. Work around to it. Ask questions that would lead you to, like you said, where do you have, how many friends do you have at your dad's house? Who do you hang out with at your mom's house? Who's your best friend? Where's your best friend live? In your mom's neighborhood, dad's neighborhood? Just a variety of questions that never really get to the ultimate issue directly, but indirectly, they'll lead you to it eventually.
I recently had a case where the mother and father, the children, the two children didn't want to go with dad supposedly, and mother denied any alienation, and on the record was saying, "Oh no, I encourage it. I really want them to have this relationship. Dad wanted the relationship," and yet there seemed to be this problem. So they both said, "Well, you can talk to the children," and I'm certainly not skilled as a psychologist, but what I did was I met with the children, and what did you like about dad, before you had this problem? And one daughter said, well, I used to like to go camping. We used to always go camping. I said, well, what if this, if we set up something, camping, like that? She said, oh yeah, that'd be fun. And we slowly worked into a situation where she kind of committed to me that she would try and would go on one of these, like a date almost, with her father. She'd try this out. And we left with a kind of a responsibility on father to set up a camping trip, and then a breakfast out that the other daughter really wanted to have a breakfast out to rejuvenate the relationship. And it was very effective. And I haven't seen the case again, so I'm hopeful that it worked. So there are other opportunities in those settings to try to be creative, to kind of cut through some of the problems that we had. And you don't even have to reach the issue who was alienating, who's responsible for it. Let's get behind that, and let's just get this started again, get the access started again.
To what extent have you all had the experience where what you've learned from the child's preference stated to you, has been dispositive? I mean, how much weight does it really carry? Because certainly parties think that's the holy grail. I'm going to bring the kid in, he's going to say he wants to be with me. Judge is going to do that then. And that's not been my experience. I'm just wondering.
Fact specific.
It's fact specific, and you got to evaluate the motive. I'm sorry, I have a problem with this, don't I? It's fact specific. You have to evaluate the child, what the back, why the child is saying what he or she is saying. And I can't think it's been dispositive. It's confirmed what I've already gleaned from the evidence presented in court to other witnesses. What they tell me it confirms that. That's helpful.
When you have a child come in and their responses to you are not perhaps age appropriate, and it appears that they've been worked over quite a bit by one parent to come in and just give the speech about what impact does that play in your evaluation?
It happens all the time.
Yeah. I think the parents are kind of foolish to think that the judge isn't going to see through it and realize that they've been coached. And I think it has a very negative impact on the parent who's done the coaching, definitely. Especially when you have these younger children who probably are not capable of telling you as eloquently as they should be able to, what they want, and they start, speaking in adult words, and yeah, it's pretty obvious.